Have you ever wondered why some families navigate the estate planning process smoothly while others face years of costly legal battles? Well, the difference often comes down to one critical decision: choosing the right estate planning attorney. I'm Ted Gudorf, and after 3 decades of helping families protect their assets and legacies, I've discovered that asking the right questions before hiring an attorney can save you thousands of dollars and countless headaches. Today, I'm going to walk you through the 8 essential questions you must ask before choosing an estate planning attorney. These aren't just any questions. They're the exact same questions I encourage my own potential clients to ask me. By the end of this video, you'll have a powerful framework to confidently select an attorney whose ethics are beyond reproach and whose expertise aligns perfectly with your family's unique needs. Estate planning isn't just about drafting documents. It's about creating a comprehensive strategy that protects everything you've worked for and everyone that you love. The right attorney makes all the difference between a plan that works when you need it most and one that falls apart at the worst possible moment. So let's dive into these critical questions that will help you make this important decision. The first question you should ask is whether the attorney is board certified in estate planning. Now, an attorney can certainly be competent without certification, but when you're placing your family's future in someone's hands, you want every possible assurance of their expertise and ethics. Board certified attorneys have completed the rigorous process that typically includes substantial practice experience, extensive peer review, detailed written examinations, ongoing education, and proof of good standing with liability insurance. This certification isn't just a fancy title. It's concrete evidence that the attorney has demonstrated exceptional knowledge in his specific area of law. At our firm, we have 3 attorneys who have completed the Ohio State Bar Association's stringent certification process in estate planning, trust, and probate law. In fact, I was among the first attorneys in Ohio to earn this certification. This specialized knowledge allows us to identify potential issues that general practitioners might miss, potentially saving your family from costly mistakes down the road. Now, the second question addresses a concern many people have but are afraid to ask: money. Understanding how an attorney charges is crucial because it affects not just your budget, but also your relationship with them. Many estate planning firms charge by the hour, which means clients are billed each time they communicate with their attorney, no matter how briefly. This billing structure often discourages clients from asking important questions or seeking clarification, which can lead to misunderstanding and problems with your estate plan. At our firm, we offer flat fee pricing that gives clients the freedom to keep in touch and ask questions without fear of running up their bill. Our fee includes 1 year of representation and includes multiple meetings, emails, and phone calls needed to complete a customized estate plan. And typically, we complete the entire initial process within 90 days. This transparent approach eliminates surprises and builds trust from the beginning of our relationship. The third question focuses on process. Experienced estate planning attorneys have developed a systematic approach that works for both them and their clients. Your attorney should begin by listening to you and asking questions about your goals, including questions you may not have previously considered. The estate planning process should feel like a partnership. You should always know what to expect next and feel comfortable asking questions if you need more information. If an attorney can't clearly explain their process, that's a red flag. Now, in our practice, we've developed the Family Estate and Legacy Program, a trademark 7-step process that guides clients through creating the best estate plan for their unique situation. This structured approach ensures nothing falls through the cracks and that your plan addresses all potential scenarios. The fourth question addresses one of the most common estate planning failures: improper asset alignment. Creating a trust is essential for many estate plans, but it's not enough to simply create the document. The trust must be properly funded with your assets, and to do this depends on the nature of each asset. Many attorneys will create beautiful estate planning documents, put them in a binder, but then leave you on your own to figure out how to transfer your assets into your trust. This is like building a sophisticated safe, but never putting your valuables inside of it. It defeats the purpose. At our firm, we make it a priority to help clients through the funding process. We offer an asset alignment workshop and workbook that teaches you how to effectively fund your trust. Additionally, through our Legacy Club membership program, we provide ongoing funding support as clients acquire new assets that need to be placed in their trust. This comprehensive approach ensures your plan works exactly as intended when it's needed. The fifth question recognizes that estate planning isn't a one-time event, but an ongoing process. Your circumstances will change. The law may change. You'll acquire new assets, dispose of others, welcome new family members, and sadly, say goodbye to others. Your estate plan needs to evolve accordingly. An experienced attorney understands this reality and should be able to explain their process for reevaluating and updating estate plans. If they don't have a clear answer, they may not be thinking about the long-term success of your plan. We created our Legacy Club specifically to address this need. This client care program makes it easy for our clients to engage with us on an ongoing basis and ensure their estate plans change along with their needs. The Legacy Club offers counseling, education, referrals, funding support, and more. Everything needed to keep your plan current and effective. The sixth question addresses a reality many of us will face: the need for long-term care. An experienced estate planning attorney should not only be willing to continue supporting your plan if that need arises, but should help you plan for such a contingency. At our firm, we have an elder law team that helps clients choose the right long-term care facility, protect their assets from nursing home costs, and even apply for Medicaid and VA benefits. This integrated approach ensures that your estate plan continues to work for you even as your care needs change. Many attorneys focus solely on what happens after death, but proper estate planning must also address what happens if you need long-term care while you're still alive. Without this planning, your life savings could be depleted by nursing home costs, leaving very little for your loved ones. The seventh question gets at the heart of experience. There's simply no substitute for having handled thousands of different situations and seen what works and what doesn't in real-world scenarios. In 3 decades of practice, our firm has prepared and supported more than 5,000 estate plans, all custom prepared for particular clients. When selecting a law firm, you should inquire not just about how long they've been practicing, but how much of their practice involves estate planning. At our firm, estate planning, elder law, probate, and trust administration are all we do. It's our exclusive focus. This depth of experience means we've likely encountered situations similar to yours and can anticipate potential issues before they become problems. It also means we've refined our processes to be efficient and effective, saving you time and money. The final question addresses whether an attorney is equipped to plan for estates like yours. If your estate is large enough that the estate tax is a potential concern, you need an attorney who regularly plans for estates with significant assets and who is prepared to deal with tax issues. Similarly, if you have special circumstances, such as planning for a family member with special needs or for the future of a family farm, you should ensure your attorney has the relevant experience. Ask about how many similar cases they've handled. At our firm, the majority of our clients are individuals or families with total assets ranging from somewhere between $750,000 to $5 million. But we also work with clients who have advanced asset protection and estate planning needs, typically with a net worth exceeding $10 million. This range of experience allows us to tailor our approach to your specific situation. If you're ready to take the next step in your estate planning journey, I encourage you to watch our on-demand workshop, How a Living Trust Can Protect You and Your Family. During this workshop, I'll walk you through various estate planning options, potential threats you may face. Now that you know the 8 essential questions to ask before hiring an estate planning attorney, you're already ahead of the game. Choosing the right professional is the foundation, but the tools they use matter just as much. So what kinds of trusts are actually being used to protect families like yours? What's the difference between a revocable trust, an asset protection trust, a supplemental needs trust, and a tax-efficient trust? And how do you know which ones you need? In our next video, Trust 101, understanding the basics of the 4 essential trusts we create for our clients, I'll break down the core types of trusts we use every day, who they're for, and how they work together to protect everything you've built.